Welcome to the No Unfinished Business podcast. There are 1,000 different ways your clients can leave unfinished business, but no single advisor can address every issue. In every episode, we'll answer the important questions to help professional advisors focused on individual clients. Attorneys, CPAs, and financial advisors identify and eliminate those planning blind spots so you can speak competently and confidently to your clients and help them leave no unfinished business. Chris, Burt.
Hey, John, how are you?
Great. Thanks for coming down. We're talking about how to avoid problems between trustees and beneficiaries because you spend your life defending and both suing fiduciaries. But if we can avoid fights, we want to do that. So for our dear listeners who probably have clients who are either trustees or beneficiaries,
Sure.
Where do we even start on stopping fights before they start?
Well, so that's a really thick question there, but kind of taking it in pieces, there's really kind of two perspectives that I would look at this question. One is, do I represent the interests of the trustee or do I represent the interests of the beneficiaries? And so starting with trustees, the thing I think that most trustees don't realize is that most of the times the beneficiaries are just looking for information. They have an affirmative duty to disclose information to the beneficiaries. And the best thing that you can do as a trustee is just give more information, overproduce information if necessary, provide monthly statements, set up a quarterly meeting if it's necessary, something so that the beneficiary feels like they're involved in the process, because 9 times out of 10, when I talk to beneficiaries about issues they're having with their trustee, it's that they feel like there are things happening in the dark, that they don't know what's going on. And the not knowing is the cause of way more concern than the knowing.
Right.
So to the extent that you can give that information out, make information available, and it's not hard.
Right. I mean, kind of two things that I hear. One, you're not saying necessarily full accountings every month, though accountings are useful for covering your backside.
Sure.
But the other side, making sure that they know what's going on. It's similar to like the old maps that may not have ever said, here be dragons. But the idea of if your beneficiary doesn't know what's going on, they're going to fill in the gaps with the worst story possible, because that's where the easiest answers are.
Well, that's 100% true. I mean, it's the whole idea that, if you're looking down the dark hallway, you don't know what's there. Your mind is instantly conjuring pictures of the boogeyman, even though there may be, a Girl Scout cookies. The opposite is easier for our mind to fill in because the not knowing is so confusing and scary to people. But you are right. This is not a call for, well, we should be accounting for every single penny every single month, because, in our world, accounting has a particular meaning that people in the non-fiduciary world may not ascribe to it.
Right.
And so that's really expensive. And there are lots of ways to do this in a more kind of casual or colloquial manner that the beneficiary will understand. And then you can highlight things that are coming up or things that maybe you're working through or dealing with so that there aren't surprises in the future.
Right. And so this is probably a good time. What do you mean by an accounting? Because it's not just tax return preparation. It's not just a list of the assets. Go ahead.
Yeah, no. So fiduciary accounting is very specific. So there are affirmative requirements in both the Texas Trust Code and the Texas Estates Code for all kinds of fiduciaries, be it a trustee, an executor, an agent or a power of attorney, where they have to affirmatively, quote, account for the assets that are under management. And what that means is that they have to literally track every single penny in and out and have all of the supporting documentation to support it. That can be a very expensive task for which the trust, the estate, or the person's assets under management by a power of attorney are going to pay for. And so that is not required on a monthly basis. It's not required on a quarterly basis. Sometimes it can be required on an annual basis. In fact, a lot of trusts we're seeing now have an affirmative requirement that the trustee do some form of accounting, whether it's that detailed or not every year for the life of the trust. They have to give it to the beneficiaries within so many days after the end of the calendar year. And then once the beneficiaries get it, what's great is you can build in language that will say, well, once we've turned it over to you, if you don't raise any objections or if you don't do anything, that you will have waived any claims you have had to challenge that accounting for the last, year or so.
Right. So what I'm hearing is, again, as the drafter, put something in there that says, look, trustee, even if you don't want to, something that looks like an accounting should be coming out once a year, just so you're on top of things.
Mm-hmm.
But also giving the beneficiary a time of, if they don't say anything, they can't just store their perceived grievances and then unleash them all at once.
That's exactly right. And I mean, you don't want to punish your fiduciary for being put in the role that in many cases they didn't necessarily choose, especially for individuals. You kind of find out after the fact. And, that's something that could protect them and kind of close the kind of causal loop on those things.
Right. Because it is something where the individual beneficiary or the individual trustee, if they're not trustee for themselves,
Mm-hmm.
it's generally somebody who's been trusted long enough. They're already in a role where they're going to be managing assets for somebody else. They may not be getting paid a whole bunch for it.
Yeah, and they may not be getting paid enough depending on how demanding those beneficiaries are. So you want to make sure that you provide protections for them so that, every fiduciary that comes into the role isn't just going to work for 6 months, find that it's too onerous and not worth the time and just throw their hands up and quit the job.
Right. So we've talked about what the trustee needs to be thinking about.
Mm-hmm.
Our beneficiaries, the people who just want their gosh darn money that somebody else wasn't kind enough to just give to them outright. What should our beneficiaries be thinking when they stare down that dark corridor and they're imagining dragons and other monsters?
Sure. First of all, ask a lot of questions. The thing about it is that if you don't ask, if the trust document doesn't provide for it or the code doesn't provide for it, you may not get like an automatic sort of kind of vending machine dispense of information every 6 months or so.
Mm-hmm.
You may be entitled to a statement every month. You may have questions about what's on that statement, why particular investments are being made. But if you don't ask the question, then you never really put it back on the fiduciary to give you an explanation. And so I would say as the beneficiary, goal number one is ask a ton of questions. If there's anything that you're confused about, the trustee or the fiduciary is there to help you go through that. And kind of red flag number one for beneficiaries is I asked the questions, I either didn't get a response or it was, objection non-responsive. It wasn't what I was looking for. And that should be assigned to a beneficiary that they may need to maybe hire counsel to kind of explore it further, because that's kind of level two is once the beneficiary asks the question, they don't get the answer. They may need a bigger gun that knows, to put a little firepower behind the question in order to kind of prompt an answer.
Yeah, and this is something that, as I think about it, people are always like, well, can you just fire off a letter to somebody? And because I don't litigate,
Mm-hmm.
and I've told this to you, I've told this to many clients, I'm nervous about sending a letter because I can't back it up
Mm-hmm.
very well. Like if it comes to blows, then I'm going to have to bring somebody like you in. So rather than have me send, kind of a veiled threat, let's see what we can do. Like I'm typically having the individuals go individual to individual.
Mm-hmm.
I will coach them on that language of ask it this way.
Sure.
Because then when anybody who is not already a lawyer or doesn't deal with lawyers on a regular basis will get deer in headlights, will get defensive, even if it's me reaching out to them.
Sure. And I think that this kind of falls into the stay in your lane concept that a lot of us have adopted practitioner wise, where if somebody comes to me and wants to redraft their trust or has, some alphabet soup of things that they want included in their estate plan, that's not for me. And that's okay. And you pick the right person for the right job. And that comes to when you think about your fiduciaries too. That should be something that your clients are really thinking about. I mean, do I want to put Uncle Jim Bob as the trustee of a $10 million trust that has all kinds of crazy investments, when I would do better and maybe have better success in the management of those assets, maybe with a corporate fiduciary or with maybe a trusted financial advisor standing in the helm who has some knowledge about what's going on. So that kind of stay in your lane concept not only applies to the back end, but I think the front end as well.
Right. And thinking about it, just when we're drafting, we've got the choice of who needs to be there. We're typically, I typically have clients think along the lines of the people you trust now with your money are probably the people you want as your executor and your trustee, because if you trust them to be your agent under a financial power, they're probably going to be the right persons. Or if you want somebody to be in charge of money for the kids, it probably overlaps that they maybe should be the trustee as well. Doesn't have to be.
No, it doesn't. It doesn't. I mean, and everybody has personal choice, but I think you and I have both seen situations where it's like, why did they put stepmom over, as manager of a trust for kids that are not hers? Or why did we put brother in as trustee over sister when we know that they haven't spoken in 25 years? That kind of stuff comes into play when you're thinking about these things.
Right. Avoiding fights but on the front end, just thinking about things. We had a client coming in to sign today. He has blended family, new spouse, and then kids from his first relationship. They are getting different assets.
Good.
And we're also making sure there are completely separate trusts. There is, one Rev trust for the kids, and there's a completely separate Rev trust that has been funded with the assets for the current spouse. And if that second marriage dissolves, the automatic terms of the trust say it goes back to the kids.
Great.
And so the kids will know about it, but they're not appointed anywhere unless Step Monster gets thrown out.
Step Monster is a good word.
But that's the point. Is like, we're keeping everybody separate. We're not putting one big pot trust. We're not like marital trusts where we're going to leave it to stepmom and then whatever's left goes to the kids. I don't like that. I don't want to, I don't want any remainder beneficiary looking over the shoulder. Just give it to somebody and cut your losses.
That's an excellent plan. I mean, I wish, some of the cases we had planning that looked like that. I mean, because a great example of a case we had was we litigated a dispute in a trust, and the stepmother was the trustee for kids that were not only not hers, they were husbands from a previous marriage, but the stepmother was the same age as the oldest child. And that caused a little bit of conflict, a lot of conflict between them, which could have been easily resolved by something that you're talking about, maybe dividing the assets into two pools and having different groups be in charge of different pools, because there was clearly enough that this family needed a trust and needed some of those protections, but this was just the wrong way to go about it.
Right. It's how do we make it easy for everybody? And making it easy means let's not have to fight this out, because the rule of thumb that you've given me and I now put in front of clients, if we have a fight, 10% of whatever it is disappears. Well, 5% goes to you and 5% goes to the other side that is clearly wrong and dumb.
Yes. And we see it often, I think maybe as many of your clients would know too, most cases don't get litigated. What I mean by that is they don't go to trial. So something like 94% of cases are actually litigated before they ever see, a jury or a judge making a final determination. And 9 times out of 10, the trust that's holding all the money is paying for everybody's fees. So this great legacy that you wanted to leave for everybody, ultimately, shave that top 10% off for the lawyers for the fight, because they're getting paid from somewhere.
Right.
And 9 times out of 10, when I'm advising beneficiaries, that's kind of the other thing is when you're thinking about filing litigation, you have to remember that fiduciary has that war chest to fight you with. And until you prove that they've done something wrong, they get to pull the money out of the trust to pay for their legal defense.
Right.
So, you have to think about both the ramifications of what happens when we settle this thing, who's going to pay, but also along the way, am I working at a disadvantage?
Yeah. And I think you bring up something that's probably a good place to start closing the conversation on. How do we know a trustee has actually done something wrong? I mean, there are clear good things of you've made distributions. There are the clear bad things. You've taken the money and put it in your pocket when you shouldn't have. There are gray lines where, where are people playing with fire? And I know from one example, the trustee was using funds to invest in his separate business. And then, had negotiated terms where most of the windfall profits went to the trustee in his individual capacity, the trust really just was treated like they got paid back dollar for dollar, but no interest, sweetheart deal for
Sure.
the individual. Where are those things where we need to be thinking about for our clients of, hey, I know you can, but this is going to cause problems, or if you're lucky, it's just going to cause some bad words. If it's really bad, you're going to, the beneficiary is going to come take the money right out of your pocket.
Sure. So I would say that at least in the trust that I've seen, the biggest thing that gets people in trouble, especially when you have individual trustees, is this belief that they can either day trade or somehow advance an investment strategy that is extremely high risk. In those cases, yes, those people may, in the short term, have an enormous windfall for the trust. But 9 times out of 10, what I see, especially when you have these massive swings in the market, like we've had over the last couple of years, individual trustees selecting high risk investments that look great on paper, but the downside is, if you miss big. And it's not a easily recoverable asset where you're going to recover a lot of value. It may just be gone forever. So I always tell beneficiaries, if you need help, sit down with a financial advisor if your investment portfolio is that complicated. But there's nothing wrong with asking the trustee or whoever's managing your funds to do sort of a portfolio analysis and kind of determine, what are we really looking for out of the trust assets, because the trustee has, the duty to invest them as a prudent investor would. And if it's, in an asset that has a 20% upside, but an 80% downside on the other hand, that's something that kind of risky investment can get you in trouble.
Yeah. So, we've got to make sure we know what's going on. I'm sure there's probably too low risk of, if you just invest it straight in cash, that's not going to be great.
That's exactly right. You have to find the balance. And that's why even with individual trustees, I always suggest that it never hurts to bring on professionals. Stay in your lane. We're coming back to that again. I may be a great plumber or electrician, but if I'm not an investment advisor, then I shouldn't be making those decisions if I'm the trustee of a trust.
Right.
Bring somebody on to help you, because then at least if something bad does happen, in the trust code, there is a defense that says, look, I relied on the advice of somebody else. Will you ultimately be removed as trustee? Maybe, but will you be individually liable for what happened? Probably not.
Chris, that's probably a great place to stop for right now. Where can our listeners find you if they have questions about trustees and beneficiaries?
Sure. So I'm a shareholder at Boyer Miller, a law firm here in Houston. So our website is www.boyermiller.com. You can find my bio, and there's my email and phone number on there if you have any questions.
Awesome. Thanks, Chris.
All right. Thanks, John.